Welcome back to the Legal Brief, the show where we crush the various legal myths and misinformation surrounding various areas of the gun world. I'm your host, Adam Kraut, and today we're talking about a bill that will provide states with funding for suicide and violence prevention. SB Tactical, the originator of the pistol stabilizing brace, set the bar for innovation and product development in the PDW pistol category. From the insanely popular SB-M4 to the adjustable SB-A3 and even kits for pump-action firearms, SB Tactical braces are available for a wide variety of firearm platforms in fixed, adjustable, and side-folding models. To get 15% off your legally transported and carried pistol braces, use the code TGC15 over at sb-tactical.com. H.R. 6747, known as the Protecting Our Communities and Rights Act of 2018, was introduced in Congress by Representative Kotko of New York. The bill seeks to create a national standard for extreme risk protection orders that states would need to comply with in order to receive funding from the federal government. The funding that's available would be to assist a state with carrying out the provisions set forth in Section 3 of the bill, which dictates the standards of the ERPOs. The section dictating the standards begins by stating that a generalized concern related to any hazards posed by firearms ownership or use generally shall not constitute sufficient basis for the issuance or renewal of an extreme risk protection order. I guess that's comforting to know that a constitutional right isn't a basis to have an order issued against you. As we've seen with several states that have already implemented extreme risk violence protection orders, an application may be made ex parte, meaning that the person who the order is sought against need not be present. An order may be issued when a preponderance of the evidence, which is the lowest evidentiary standard, shows that a person poses an imminent, particularized, and substantial risk of unlawfully using a firearm to cause death or serious physical injury to themselves or others. The order cannot exceed 21 days unless the person is detained for or submits to an evaluation for commitment to a mental institution or for assisted outpatient treatment. If that happens, the preliminary order may be extended for the period of time that they're being treated. In addition to the ex parte order, if a person meets the applicable standard for the involuntary observation, temporary commitment, or any other procedure that begins the state's process for involuntary commitment or assisted outpatient treatment, the court must order the person be committed or attend that outpatient treatment. Any restriction imposed by a preliminary ex parte order shall be limited to only receiving firearms or transporting or carrying firearms in public. So it would seem, at least, that the ex parte order would not strip a person of their ability to retain firearms they currently have. They just wouldn't be able to get new ones, move the ones they have, or carry a firearm in public. Within 14 days of the ex parte order, a hearing must be held with the person who the order is against in order to determine whether to grant a permanent order. The person will have an opportunity to appear with counsel, present opposing witnesses, and cross-examine the petitioner or any witness against them. At that hearing, the state or petitioner shall have the burden of establishing by clear and convincing evidence, which is the middle evidentiary standard, that the respondent poses an imminent, particularized, and substantial risk of unlawfully using a firearm to cause death or serious physical injury to themselves or others. Assuming they do so, the permanent order restricts a person from possessing or receiving or attempting to possess or receive a firearm for a period of up to 1 year. If the court determines that there is a probable cause to believe that the person already possesses a firearm when the order is issued, the court shall issue a warrant ordering the seizure of the firearm and shall further order the firearm to be retained for the duration of the order. When a law enforcement officer takes possession of a firearm pursuant to a warrant, they have to provide a receipt, which includes the make, model, caliber, finish, and serial number of the firearm. Firearm seized shall be retained by the law enforcement agency that seized it or by a third party not prohibited from possessing or receiving a firearm for the duration of the order. The bill does place some limitations on the seizure of firearms. In a case where the location searched is occupied by multiple people and the officer executing the warrant determines that a firearm found is owned by an individual other than the person named in the warrant, the firearm may not be seized if the firearm will be stored in a manner that ensures that the person named in the warrant does not have access to it or control of the firearm, and there's no probable cause to believe that the person who does own the gun does not lawfully possess the firearm. It also states that if the place is occupied by multiple parties and the officer locates a gun safe, which the officer determines is owned by someone other than the person named in the warrant, the contents of the safe shall not be searched except in the owner's presence and with their consent. Like some states, the bill allows for the person subject to the order to petition the court to have it rescinded. However, this option only gets to be exercised one time. After an order expires, the bill would require the return of firearms within 5 business days. As you may have guessed, there is the ability to petition to renew the order, but that can only be done 2 times. The bill would also alter the language in federal law that deals with prohibited persons subject to restraining orders. As titled, the bill obviously seeks to show that it's attempting to protect the community and the rights of people. However, it falls short by failing to provide due process prior to restricting the ability of a person to exercise their constitutional right. The bill is currently sitting in committee and will likely die there, as this current session of Congress doesn't have much time left in it. But be wary of future iterations of this bill being introduced to us as reasonable or common sense measures. That's it for this episode. If you learned anything from the show, help us out and hit that like button and make sure you share it with your friends. Don't forget to get subscribed, and if you enjoyed the video, consider supporting us via the links down in the video description. Be sure to check out the Gun Collective podcast on iTunes, and as always, thanks for watching. Yes. So be stopped as if he's protecting the community. Yeah. Cotco of New York. And I'm sure I didn't say that right. Good timing. Way to screw up.
The shirts worn in today's video on the Gun Collective have been provided by Patriot Patch. Closed captions have also been brought to you by Patriot Patch Company. Be sure to click the link in the video description to check out all of their great products, including their cleaning mats.